The Supreme Court has ruled that constitutional courts cannot prescribe timelines for the president or governors while they decide on bills passed by state legislatures. Calling such directions unconstitutional, the court delivered its opinion on a presidential reference that sought clarity on whether courts could mandate time bound action under Article 200 and 201. A constitution bench of Chief Justice B.R. Gavai, Justice Surya Kant, Justice Vikram Nath, Justice P.S. Narasimha, and Justice A.S. Chandurkar struck down earlier directions issued by a two-judge bench in the Tamil Nadu case, which had fixed deadlines for governors when dealing with bills. The bench also held that courts cannot grant deemed assent to bills pending before a governor. It noted that the two-judge bench's use of Article 142 to grant deemed assent to 10 Tamil Nadu bills was beyond its authority. The court said it cannot assume or override the constitutional powers vested in the governors and the president. At the same time, the bench clarified that governors cannot indefinitely withhold assent to bills. It said that within India's cooperative federal structure, governors must engage in dialogue with state legislatures to resolve concerns and should not adopt an obstructionist approach. In an important clarification, the court said while constitutional courts cannot question governors' actions, it can, in limited circumstances, take up for scrutiny prolonged inaction on governors' part to frustrate objectives of a bill and determine whether the delay was deliberate. It ruled that the governor has the discretion either to return the bill with comments to the House or reserve it for President's consideration, and that discretion of the governor cannot be whittled down. It, however, stressed that the governors cannot indefinitely withhold assent to bills passed by state assemblies. It is in India's cooperative federalism, governors must adopt dialogue process to iron out differences with House over a bill and not adopt an obstructionist approach.